Well, I'd like to welcome you all to the last panel of the day, the General Counsel panel. We have an all-star crowd on the stage here, starting from the right, Reggie Davis from Zynga, Sam Fleischman from Salesforce.com, Lawrence Wilson from Yelp, Kent Walker from Google, Kirsten Mellor from CafePress, Mike Jacobson from eBay, Chad Ho from Hulu, and Cary Berger from eHarmony. If we'd actually thought about this, this is probably not a security best practice to have this whole high-level group in one place at one time. But we are delighted and very honored to end the conference with such a high-level group talking about best practice issues. We want to also encourage you not only to participate in the discussion, because we will take questions during this panel, but to continue the discussion after. We've got a wine and cheese afterwards starting out there, and this panel, because they're so distinguished, they've already got the wine to start. So we hope that we hope this will be a we hope this will be a great and lively discussion. And for those of you, because I know a number of you have been asking, who were not able to attend each session, given that we had 3 running simultaneously since this morning, we will be emailing you with information so you can watch the panels you missed on video. So let's start, and actually if I can just ask at the end, Reggie, can each of you just introduce yourselves to the audience in terms of your background and the company you're with?
Sure. My name's Reggie Davis, and I've got an avatar in the book because I'm not as good looking as Jim Batchelder or Bill Cosden, so I had to go with an avatar. A little shout out right at the start there for you guys. I was an attorney in San Francisco for 10 years. Then I was at Yahoo for 10 years, and for the last 3 years, I've been in a company called Zynga. When I started at Zynga, we were 114 employees. We had $29 million in the bank, and we had one office, and legal was crammed in with the culinary staff who was chopping meat and serving lunches and dinners all day. 3 years later, we just topped 3,600 employees. We have $2 billion in the bank, and we have 30 offices worldwide. And the legal team has grown from 1 to 38 in the last 3 years. So it's been, I don't know about best practices or evolving. I've just been hanging on for the last 3 years and trying to not get in the way of the business and enjoy the growth. So that's my story.
Good afternoon. My name is Sam Fleischman. I am the corporate legal attorney at Salesforce. I manage a bunch of different functions, including corporate and securities, IP, patent, M&A, investments, real estate, a whole bunch of stuff. I've been at Salesforce for about 9 years now. I started in 2003 with about $60 million in revenue. We're now at $2 billion in revenue. We're a subscription business, a cloud computing company. Many of you probably heard of it. Before that, I was at Oracle for 4 years, doing mostly IP work and commercial licensing. And before that, I was at Brobeck, Flager, and Harrison, doing general civil litigation.
Hi, my name's Lawrence Wilson. I work at Yelp, which is hopefully everyone's favorite local review website. My background is probably a little bit different than the others in the sense that I didn't take the normal traditional big law firm route to in-house. I actually went directly out of law school into the startup world. I've loved it ever since. Can't imagine ever working in the law firm world, though I'm sure those of you here who are there think it's the greatest thing since sliced bread.
Sliced bread's not too bad.
Okay. So Yelp is also probably one of the smaller companies here on the panel. We have a really small legal team. There's only 4 of us. I think we are still with the kitchen crew. We recently went public. It was a great event for us, but we have a pretty big mountain to climb from here.
I'm Kent Walker. I'm general counsel over at Google. I ended up at Google after being unable to hold a job at pretty much any place else in Silicon Valley, including over at eBay when I used to work for Mike. I was a federal prosecutor for about 5 years. I worked for a law firm for a couple of years. I worked at eBay at a startup which went from 0 to $12 billion in market cap to bankrupt in the course of 3 years, which is a perfect Silicon Valley experience, and have do a wide variety of things at this point, from antitrust to privacy to intellectual property and information law, and every so often, do the occasional commercial contract or real lawyering.
My name is Kirsten Mellor. I've been in-house for about 13 years. Prior to that, I did some stints at Big Law. Testa, Hurwitz, and Brobeck take nothing from the fact that neither of those firms exist anymore. I've been a general counsel, an assistant general counsel, and corporate counsel in private and public companies for that time. I survived the first dot-com boom, and I'm still in internet companies, so I wear that badge with a fair bit of pride. I am the general counsel of CafePress, which is an e-commerce platform that allows users to create and sell customized merchandise based on their own content or buy products with licensed content in our marketplace of about 325 million products, digital, virtual products. We run a number of other e-commerce brands as well. We just went public in 2012. As I like to say, we were that other Bay Area internet IPO in 2012. Little quieter. I joined the executive team at CafePress in early 2011 to help them bring their legal department up to the public company life for which they were aspiring. And after 13 years in operation, that meant a lot of changes and a lot of best practices that needed attention. So I am pleased to be here.
Hi, I'm Mike Jacobson. I'm the general counsel at eBay. I will shortly celebrate my 14th anniversary at the company. I was the second lawyer there. I'm now, there are 175 or thereabouts. And before that, I was in private practice at the Cooley-Godward firm. It's been an interesting ride for the last 14 years. The company's obviously changed a lot. The industry has changed a lot. E-commerce has matured, and there are a lot more of us in e-commerce than there used to be.
I'm Chad Ho. I'm the general counsel at Hulu. I didn't come here thinking I would be that guy, the only one wearing a tie on the panel. I apologize. I did loosen the top button, if it's any consolation. I started with Hulu when the company began 5 years ago. I was the first lawyer there. We now have 10 lawyers at the company, nowhere the size of some of these other companies, but we're chugging along. Things are going very well. I love my job. I learned that as a GC, you don't actually have to know anything. You rely on other people who know things, which is wonderful. Call people like Ian. I started out as a litigator. Quickly discovered that litigation wasn't consistent with my temperament. So I transitioned over to corporate law, big firm, private practice. My first in-house job was doing production law at ABC Television. So I got to hang out with stars for, a few months. That got boring after a while, and my job prior to Hulu was at MySpace. Started there when the company was small, less than 100 people, and at the time I left, we were over 1,200 people, and it was actually at one point the most visited website in the US, which a lot of people have forgotten since that was a long time ago.
Hi, I'm Cary Berger. I'm the general counsel at eHarmony. I've been at the company for about 2 years. eHarmony is an online dating company. Most of you have probably heard of it. We're in 5 countries, and then with an association with a German company, we're in 11 other countries in continental Europe. The company's private. We're based in Santa Monica, California, about a mile down the road from Chad's office, and we have about 250 people. Prior to eHarmony, I was at Broadcom Corporation, the semiconductor company. I was the second attorney there, started in 1999, and that company had about 600 people when I started and grew to it's over 8,000 today. And during that time at Broadcom, we did close to 50 acquisitions of smaller semiconductor companies and really handled a wide range of legal matters. Before that, I was at Irella Manella in Los Angeles for 10 years, doing mostly corporate finance and working with smaller private companies.
So as you can see, we've got a very interesting and diverse group of companies and individuals represented. The program today is on best practices, and I wanted to ask each of you if you could tell me, in your company, how do you develop best practices? First of all, how do you develop practices and procedures? And second of all, how do you identify which practices and procedures actually are best practices or even good practices? Because certainly there are practices like backdating that were very common in Silicon Valley for many years that probably is not a best practice. So how do you develop practices and procedures, and how do you know which are good ones and which are just things that develop? Reggie, can I start with you?
We can, but I won't be particularly helpful because I've given this a lot of thought, and I'd like to say that we've got this highly complex methodology of coming up with what is a true best practice. But what I can tell you is the business has done well, which has enabled us to grow the legal department and actually attract some really senior folks who showed up with best practices. So we actually sort of in a real-time, short period of time, brought in some fairly senior people who could help us figure out how we were going to deal with privacy, how we were going to deal with corporate matters, litigation, et cetera. And they brought with them a lot of good skills and practices from companies around the Valley. I was at Yahoo for 10 years before I was at Zynga, so learned a lot there. And one thing you don't typically hear at Zynga is, oh, that's not the Zynga way. We don't do it that way. We do it this way. You don't hear that a lot because we're learning as we go and we're evolving the practices real time. But we've been fortunate enough to have some really strong people show up and help us kind of craft our practices real time as we roll it out.
Sam?
Well, you know, similar at Salesforce. I mean, best practice at first is just practice and getting it done, and getting it done quickly and efficiently. But as we've evolved, and over the 9 years or so that I've been there, there's no best practice that I can think of that we've adopted that hasn't been very much involved with the business. So it's a best practice both for the legal department and for the business. And if you don't have both things working together, it can't be a legal best practice. And so, when Ian mentioned this topic to me over the phone last week, a couple of things immediately came to mind. One thing we used to do is we'd have a contract for our customers that was in writing that we'd send to them and that would be negotiated, which was a different form than the click-through one that a small customer might get online and just accept. And naturally, the one that was online was a little bit more favorable for us than the one that we would negotiate to start with. And what we wound up doing is making the two harmonious. So you got the same terms whether you clicked through or whether you negotiated and you wanted something in writing to sign. And I think, any outside lawyer would tell you that probably, your outside counsel is going to tell you that's not a good practice. But for us in our business, it is a good practice because it cuts down on negotiation. We want a good relationship with our customers. And when they see terms that they don't like in a click-through, they immediately want to negotiate. So if they see something that's fair, you wind up getting more business that way because you can just do more volume. So that's a best practice that may not necessarily be purely legal, but when married with the business, it actually made a lot of sense, and it's worked a lot for us. So it's been really iterative on the business side to come up with these.
Lawrence, how do you develop best practices at Yelp?
Yeah, I'll probably just echo what Reggie and Sam just said, but for me, one of the most important things is really understanding the risk profile of the company you're representing in the first place. I already kind of mentioned I don't come from a big firm background, so I don't necessarily come with the same risk profile in the first place. But what I see happen far too often is more conservative lawyers applying a more conservative risk profile to companies that are in young growth mode, where it's probably not appropriate. So you might end up with a Chevron type risk profile for a company like Pinterest or Quora, which doesn't make an ounce of sense in my mind. So that's really where I start, is trying to understand the risk profile that we have and the type of problem we're trying to address, and find other companies in the same position, how they're solving that same problem.
I thought a lot about best practices when we were speaking last week, and I think I had a little bit different thought about it, which was my best practice is making sure that my business people understand what magic wand I'm throwing over our business that sort of makes it okay. I get asked all the time, like, can you live with this? Are you okay with this? And it's interesting because I think that we are all in very fast-paced companies. Mike and I were just talking about how there's very little case law to support some of what we do. So it makes it very difficult to build a policy around what you think. But what I have spent a lot of time doing in the year and a half I've been at CafePress is making sure that my executives understand the legal framework and context of what we're doing that is out there. It is a lot easier to impose a policy or a best practice when your executives understand why you're doing it. So to that end, I have actually made our senior executives at some retreats sit in front of our content usage policy tools and try and do it themselves. It is a very interesting experience for a CEO who can speak very eloquently about what our business model is, but needs to look at the nitty-gritty of what we do on a review basis and understand the scale of what we do. We look at hundreds of thousands of images a week to confirm against intellectual property rules and rights on our site, against offensiveness standards on our site. So that this context made me think a little differently, which is, what is the best practice as an in-house lawyer that I can do for my business? And that is to make them understand we're flying without a net sometimes, but there's definitely a net down there, and we are going to get caught in it if we are not looking for ways to lead.
Mike?
I think there are lots of different sources of best practice. Some of it you cobble together yourself because there really is no other place to start. A lot of it comes from the experience of the people you bring on board, particularly as you become larger. And as I said, we're a big law firm, effectively, and we have a lot of input from folks who have good experiences elsewhere. Some comes from outside counsel, particularly if you ask them. A lot comes from trying to think about the universe is sort of walled in a couple of places. One wall is, be it established case law or regulatory pronouncement. There are just some things that you cannot do, and sometimes you have to spend a lot of time explaining why, if you say free, you actually can't charge. But nonetheless, that is true. It is definitely not a best practice to allow people to say free and then charge money for it. So you have sort of that at one wall, but the real art and science of creating and thinking about best practices is taking what your business is aiming to do, and trying to figure out how, looking at it almost from the customer's point of view. What is the customer going to accept? What is the customer going to like? And this is obviously not a pure legal analysis. This is a legal and business analysis. But assuming that I have to start with I can't be on the wrong side of that left wall. What do I do that maximizes the objectives of my business partners, and at the same time minimizes the amount of affront that I'm creating across my customer group? Because the reality is, and we have seen this, I want to say hundreds of times, long before we have a regulatory issue or a litigation issue, we usually have a lot of upset customers. And if we can figure out how to get our objectives done without upsetting our customers or third parties, rights owners, what have you, then we've probably gone a long way toward developing a best practice, even if we don't call it that.
Chad?
For us at Hulu, best practices is not about eliminating risk. You'll never hear an outside lawyer admit that when giving advice to an in-house person. But there's no such thing as completely eliminating risk. You can do everything right and still get in trouble. And for that reason, all of what these guys have said before me, completely agree with. You sit down with your business folks, you identify the risk profile that makes sense for your company. But at the end of the day, at Hulu, we like to talk about what if things go wrong? Because inevitably, something will always go wrong, no matter how well-intentioned you are. And that's where we come back to the New York Times test. So what we like to talk about at Hulu is, does this pass the New York Times test? Is this something that if someone were to ask us about, we could stand up with a straight face and credibly defend what we did and why we did it? And if the answer to that question is yes, and it's consistent with the risk profile that we identify for the business, then we're comfortable adopting that as a best practice.
I'd say one of the things that struck me moving from kind of the hardware world when I was at Broadcom into the e-commerce world of eHarmony is I felt much more comfortable in this world collaborating with other companies, both with companies that we don't, directly compete with, like Chad's company and Lawrence's company, but also even with our direct competitors. And so one of the things that we've done to, I think, evolve our best practices has actually been to kind of go across the aisle. I work with the folks at Match.com. I've worked with the folks at JDay. We've worked on kind of evolving safety practices, dealing with some of this, new fall and snow that comes down, and trying to, build consensus on really what's the best way to address some of these problems. And then practically speaking also, on patent litigation, we've actually taken the step of sharing counsel, not just forming a joint defense group, but actually sharing counsel with as many as 6 or 7 people. And it's been, very effective in terms of not only the economic results, but it enables us to run more efficient practices within our companies, because we can all take turns at different points in time of serving the lead role on the case. Maybe one in-house attorney is better at settlement agreements or cares about those more. Another one may be more focused on the retention or the fee structures. And I found that those collaborative processes have been really a refreshing change.
So at this point, we're going to go through and cover a number of different topics, but much more in a free-form discussion. So we're not going to go up and down the line as we did. And the first topic that we wanted to cover was cross-border issues. All day today, we've been talking about different best practice issues. And, question is, how do you attempt to create uniform policies or when you're operating in many different regions? Do you go with a single policy? Do you localize? Mike, what's your thought?
Well, the answer, of course, because I'm a lawyer, is it depends. The question of to what extent can you maintain a common policy across many different countries is really dependent on which of those countries is going to be able to essentially drag you in and subject you to their rules, their laws, their lawsuits. And the good news is that we seem to be heading towards a more uniform view of what it takes to quote-unquote target a country, which is the nomenclature. The bad news is it's real easy to find yourself in a country even if you don't have people there. Obviously, having an office is one strong indicia that you're targeting a particular country. Spending marketing dollars in that country is another strong indicia that the courts will look at. Selling your goods, whatever they may be, in the local currency, using the local language are the other two that are usually looked at. Once you have decided as a business matter that you are going to be localized, that you are going to be in the country, then you have to try to figure out to what extent do I really need to change the practices that I've used, be it in the US or more generally. And that does take a little bit of careful look at what the laws and rules are, but also at a practical level, what is actually done in the particular country. One of the things that has been hardest for me one of the hardest things that I learned as we became globalized is there are many different approaches to law. The U.S. approach is basically you have laws and the laws get enforced. So if there's a law in the books, you better pay attention to it, because if you don't, you're liable to get into trouble. Many states have a somewhat different view, and they have all kinds of laws, but many of them are not enforced. And that's very intentional. And so you need to, in those cases, actually have someone local who can tell you, yes, you need to worry about this one, but no, you don't need to worry about that one. My favorite being the pornography laws in Amsterdam or in Holland, which are amongst the strictest in the world, rival Saudi Arabia. Most people don't know that. You know, it's as so much of what we do, it's a judgment call in terms of there's obviously great efficiency in being able to use the same rules at all times. At the same time, you do not want to get into the lowest common denominator issue, because if you are going to be perfectly acceptable everywhere in the world, the odds are you're leaving a lot of money on the table somewhere. And it becomes, again, one of these mixed questions of law and business as to what you can do generally and what you have to modify locally.
Any other thoughts on international issues? Well, another topic that we want to cover is privacy. That's an issue that increasingly every company needs to address. And Reggie, can you tell us a little bit about some interesting things you've done at Zynga?
So one of the ways you can learn best practices is to reach out to the regulators. And when I was at Yahoo, we're at a practice of going and meeting with the FTC on a regular basis to say, hey, this is what we're doing around privacy and security. You know, here's our privacy center. Here's our privacy policy. Won't rent, share, sell your information unless otherwise disclosed. And obviously the harder part was all the back-end security. So we would go out there and talk to them about the things we were doing and get feedback from the FTC. And one of the things I wanted to do when I landed at Zynga was do the same thing, went out and met with them. And a lot of frustration at the FTC that companies in the Valley and elsewhere aren't doing what they do best as it relates to their users around privacy issues and making it more consumable and digestible for the users. So we launched a game called Privacyville, and it literally is the gamification of our privacy policy that looks a lot like an island where you go and third-party data, collection of data, use of your data, mobile data, sort of the hot topics. You would click on those, and by going through answer questions, and at the end, we would incent you with Farmville coins, basically, so you could then go use them in-game to buy and purchase things. It was the world's first incentivized, we believe, privacy policy, and we saw something on the order of a 25% increase, 25-fold increase in the time and the amount of people spent looking at and thinking about privacy on our website. So it actually was pretty motivating. Now, of course, they just wanted to get, for the most part, the coins and play the game and get through it, but at the same time, they learned a lot about privacy. The FTC loved that. We've become somewhat of a positive poster child around ways companies can go in and actually use what it is you do to better help your users understand privacy. So that's turned into a best practice for us, and we reached out to the regulators for the inspiration and motivation around that.
Other thoughts on privacy?
It's certainly very much coming issue all around the world, and increasingly the questions are going to involve around meaningful choice or meaningful decision making on the part of the consumer. It's going to take a while, but we've already heard in one of the sessions about this vast, significant increase in litigation, even in the absence of clear rules at the federal or state level here in the U.S. And Lordy knows in Europe and elsewhere, it's a strong, hot-button issue that is getting a lot of attention. So it's something we're all going to have to, we're going to have to spend real time figuring out how to do what we want to do from a business perspective while still keeping clear of the minds that are out there.
I think part of the challenge here, and it goes back to the earlier comments I had about best practices, is that the landscape is shifting in a lot of different ways simultaneously. Perhaps most fundamentally, I think it's shifting on a technological basis. The world gets increasingly complicated. Different systems crash into each other in unanticipated ways. So we'll have generations of effectively privacy bugs, the way we have security bugs, that were unanticipated by anybody, and yet perhaps inconsistent with a company's representations or rules in one country or another. I think the legal landscape is shifting simultaneously. Mike alluded to Europe, where obviously they've traditionally taken a much more skeptical view of privacy, particularly when it comes to companies as opposed to governments. The European Commission is in the midst of a multi-year re-examination of its privacy directive, which will have implications for the way that companies put cookies use cookies to facilitate communications back and forth, and a number of other things. And I think one of the challenges for American technology companies is that there are not as many technology companies that are based over in Europe. So to some degree, it's harder for us to make clear the technological realities that underlie sort of high-level pronouncements and principles around privacy. I think that's going to be an interesting challenge for all of us as well.
So I think I might be unique up here on the dais in that Salesforce is a B2B company, and so our customers upload their data onto our servers and manipulate the data through our applications. And so in Europe and other places, most of the privacy laws are on them because it's how they manage the data, and it's incumbent upon them to understand when they have permission to ship it overseas, when they don't, where it's stored, that type of thing. And so for us and for our in-house lawyers, there's a big process in the contracting about educating the customer about what privacy laws may or may not apply to them. And that's its own set of wrinkles because, of course, you don't want to give legal advice to your customer or your prospect, but on the other hand, you want to give them comfort that what they're going to be using the system for is kosher. And so I think that's a somewhat different perspective. Maybe others have that as well. But essentially, we've got end users who have to know something about privacy, and many of them don't. So that's another wrinkle that we've got to deal with every day.
I think one of the things you're hearing from regulators is a frustration with the difficulty that people have learning about privacy. So Reggie's example of having to incent people to go through a privacy policy, or your example of people just not understanding a lot of the basic privacy rules that govern what they're doing, I think reflect the difficulty of trying to explain extraordinarily complex information practices in ways that are short and simple and easily understood at a ninth grade reading level and all the other things that the regulatory framework would encourage. I'm interested in people's experiences. I'm starting to hear more and more that regulators around the world are dissatisfied with a notice and consent kind of model and moving instead to an approach of sometimes called privacy by design, is sort of a strong version of privacy by design where choices are made for users in line with the preferences of people who would urge the protection of more private information. Are any of you seeing that or have
Yeah,
thoughts
so
on it?
in terms of the technological disruptive time that we live in now, I mean, these devices are going to be 4 times as strong as they were this year, 2 years from now. Everybody's going to be sitting on a cloud, connecting to an app, and you could be running most of the company's apps at the same time on this device, and a user could be doing a lot of different things and hopefully going back and playing a few Farmville games as they're doing it. But whose privacy policy governs at what point? What's the expectation of that user at any one time if we've got 5 or 6 or 15 apps open and running simultaneously off a cloud on this device as I'm doing my activities? And that's what I think scares the regulators the most, is they don't have a good sense of where they would like the answer to that question to be in terms of what's the user's expectation and how they're going to regulate that, and they don't seem to be able to keep up. So I think there's a lot of nervousness, but also at the same time, realization that they can't move too quickly to legislate where it should land because it really could limit technology and the development of a lot of our companies. So it's an interesting time.
And there's no question there's a tension inherent in the complexity of the technology and the challenge, as you just said, Kent, of actually simplifying all of this for the average person to understand. That seems like a problem that isn't going to go away anytime soon.
Yeah, there's the simplification to make sure that any kind of notice is transparent and understandable for the user when it comes to privacy. The other piece of it and the tendency, by the way, as lawyers tends to be, let's think about that because we draft things, we want it to be, clear and transparent, et cetera. The other piece of it, though, that we really think about a lot is, does it work the way it's supposed to work? So going back to all of these technological innovations, when a user clicks on this button and selects this choice, what does the workflow look like in terms of the flow chart for the product features? Because there are tons and tons of subsequent screens and features that get influenced if that's the way your product is designed. And when you talk to the developers and engineers and you sit down with them and you say, hey, we just spent hours and hours, days, weeks, months, figuring out the perfect language, the perfect flow chart for how this is supposed to work. Will it actually work when you test it? And a lot of times you get this look like we're not sure. And so we always encourage people from day one to talk about not only the language in terms of how to make it transparent, but also make sure that it works the way it's supposed to work. Because if it doesn't, all the language in the world isn't going to help.
I think that's a good point. Closely related to privacy is the whole issue of security, and in particular, data security and data retention. Cary, do you have some thoughts on that?
Well, it's no coincidence that you picked me, right? Given that we were in the news last week and mentioned a couple of times today on some of the data security panels. And, it's a tricky area. When we got hit with that issue last week, it was one of these things where you find the results of the crime out there, but there's almost like no evidence of the crime at that. There's no broken locks. There's no evidence of any kind of tampering. And now you're trying to figure out, how did this happen when people are waving this in your face? And in terms of, best practices, I think the biggest thing is to kind of put labels aside of whether is this a legal department problem, is this an IT department problem. We had really an interdisciplinary force working really nicely, I think, to address this. And we were really we had our communications department there, we had our IT department there, we had legal there, but legal was largely in kind of a project management role, dealing with these different functions, and with the end goal of, people from the public's view, they think you're just talking about, you're going to do your bare minimum legal compliance, but internally, it's really about restoring that customer confidence or maintaining it and dealing with that. And the biggest strain of that whole thing is on our customer service department, and getting them ready, and because they're going to get the barrage of calls and things. And I think that's where I think it can be very fun to be in-house, because you're getting to work with all these other departments and sort of helping them, coordinating things. But it can also be very challenging, because it really forces you to kind of tap into those skills and your ability to influence people in a way that maybe you don't have in the courtroom or in the law firm or what have you. I don't know what other people's experience has been.
I think both you and Chad are talking about making sure as a best practice that you influence the very product development of the company's services or products. And sometimes it can be very hard to convince an engineer that you should be sitting in the product development meeting. But I can't, stop saying to them that you tell me early we can fix it before you build anything, before you waste time, and before you have to have a conversation with me when you're 2 days away from launch. So if we're going to put that in the theme of a bucket of best practice, it's make friends throughout the company. Get yourself invited to meetings. And sometimes that's by just being an observer and not trying to guide too much. And sometimes that's being the facilitator when the proverbial, stuff hits the fan, and being a hero to a business group on occasion when you have to. So I like to think of that as sort of, the proactive hat of being in-house. You do get to see things when they're sort of warty and ugly, which you don't see at all as an outside counsel. And you have to react accordingly and be fairly unflappable when you see stuff that just makes your eyes bug out. You're like, how could anybody build something that way? But then you have to remember that you went to law school and they didn't. So, but it is what makes our jobs very satisfying.
So another issue that most companies have to grapple with are IP best practices. We've talked during the course of the conference of copyright practices after SOPA, copyright and trademark takedown policies, software patents. How does a company start dealing with IP policies and practices?
Well, I think, as we've said, I think IP is at the lifeblood of most of what we do. And again, we're seeing dramatic changes in all the different components of that. Software obviously is vital to all of the internet companies, and the copyright protections around that are very much in dispute. We recently had our dispute with Oracle, which I think came out in a good way for most companies in the Valley, trying to maintain what had become relatively traditional principles of the fact that software languages per se and APIs are generally not copyrightable. But the larger question is, how does questions of fair use and the ability of different entrepreneurs and creators out there to build on other people's work evolve in different ways, and what are the legal boundaries around that? And we're seeing that from a company like YouTube, which has been around for probably 7 or 8 years now, to a company that's just getting started like Pinterest, whose whole model is around DMCA takedowns and relying on that. So that's a fast evolving area, and I think there is a lot of on-time, real-time collaboration between those companies, looking at what are your takedown practices, what are your DMCA approaches, how can you make common cause on a lot of these issues with regard to amicus filings, because in many cases the suit against one is a suit against all. We've seen similar kinds of things when it's come to trademark issues, where again the principle that animates a lot of what's been done in the Valley is trying to benefit consumers by making sure that the core aspects of American trademark law, which are focused on avoiding customer confusion and making sure you're getting what you're paying for, aren't broadened into sort of special interest protections that go far beyond that. I know eBay has been a leader at that with its Vero program, the Verified Rights Owner program. I can't remember what the E stood for, but and Google and others have tried to do similar sorts of things to make sure that where there are legitimate demonstrated instances of counterfeiting and the like, those materials are removed quickly. But there's also a certain amount of pushback with regard to unjustified trademark claims where people are trying to sweep too broadly. And then lastly, and perhaps most in the news right now, the questions of patents, and particularly patents around software. And whether or not you think that software patents were a good idea or a bad idea when they were more or less authorized by the Federal Circuit in 1988 in the State Street case, I think there's no question but that patents have become, and software patents have gotten to some degree out of control. We're seeing a real deluge of low-quality, questionable patents that are out there with companies building up portfolios largely for defensive use, which is, in my opinion, kind of a deadweight social loss, with rules that have worked very well around patents for traditional industries like pharma, not working very well at all for innovative new companies that are in rapid technological product cycles that have lower levels of R&D that they need to protect, that have patents, that products where every one of the smartphones sitting on this table arguably is covered by 250,000 patents. That's not a scalable model, and there's an argument that in our space, the patent system, which works very well to incent innovation, actually retards innovation. And again, as an example of where we need to work together, I think, collectively, as companies on the cutting edge of this, to see if we can change the best practices, change the way the policy and the law actually work.
Which doesn't seem to be the way we're going now, right? I mean, right now it's a big arms race and everybody's buying up used portfolios and big packets of patents. And I mean, even Zynga, I mean, we have a little bit of a keep our head down, work as hard as we can. We've been aggressive as possible around filing for patents and now have 54 issued patents and 500 applications, and we're 3.5 years old. I mean, we've been hustling hard on patents with the hope that no one comes after us other than the trolls, because everybody's going to have a troll come after you. But nobody comes after us for anything that we're not positioned to defensively protect ourselves around. And that's just the environment that we live in. So it's a tough arms race. And for young emerging companies like ours, or many of the companies on the represented here, it's a challenge. How are you going to protect yourself long term and not get pushed around?
To stress the positive, though, what is fascinating is how many great companies are still being started in that environment. So you have a Pinterest that Kent just mentioned, and YouTube back in the day. So many companies right now are being started that are standing on a little bit of questionable legal ground, but they're doing amazing things. They're really developing quickly, and they're going to figure out the problems later. That's the approach. That's the approach that has really worked for Silicon Valley in the past.
And you hope that continues. I mean, the worry is that if the more drag you add to that, the more reluctant the venture capitalists
Eventually,
are to
the pendulum
sue,
swings the other way, right?
Any other thoughts on IP?
Okay. I think we're all talking about is disruptive business models for intellectual property, and CafePress has been accused of lots of things in its long history, but the application of current IP law on what we do from a digital perspective is very difficult. So Mike and I were talking about how there's not a whole lot of case law other than where eBay has been sued to help us build policies and practices. Awesome. And I think YouTube's a good example too, where it was a highly disruptive business model to the entertainment industry. And the technology that they developed in response to getting sued almost into the Stone Age was somewhat amazing and unprecedented. So I think we're going to continue to see the evolution of IP in the digital space with a company like Pinterest, CafePress, another example, where the user can upload anything onto our site to print. Depending on your position, you would call that theft of IP, or you would call that something else. And we've seen a smashing of the channel concept in distribution in e-commerce, the smashing of international borders on distribution of products. What difference does it make where you're sitting when you look at that website? We all try to figure that out. But best practices around things that have never been done before are rather difficult. And we do our best based on case law, but we still receive thousands of C&Ds a year. Some of them from very smart people who get it when we explain the model to them, and from people who are convinced that we owe them hundreds of thousands of dollars in damages because one image was sold through our site. So, I tell the lawyers who work for me all the time, part of your job is educating in making sure people understand what we do and how we do it. And it's again, and I go back to that's why this is so much fun. And we are all sitting in a very interesting world where I don't think 4 years ago the phrase user-generated content meant anything to anybody, really. And now it's something that we can throw around very easily and as lawyers understand, so.
Well, we want to open up the panel for audience questions. I have one last question for the panel, but I want you to start thinking about your questions because we do want to make it interactive. And if you can go up to the mics to ask questions, that'll be ideal because then everyone will be able to hear the questions. But I want to ask one last question dealing with best practices around age-appropriate content. We had a panel earlier today on child protection, and I know the issue of age-appropriate content is something that Hulu deals with a lot. Chad, how have you handled best practices?
Sure, I won't spend a ton of time on the specifics around the subject matter for companies that this isn't relevant for, but I do think the mindset that we went through in thinking about this area illustrates a lot of the themes we've talked about and could be helpful and analogized for other contexts. When we launched the service, we had a decision to make whether we would require people to log in and basically confirm their age in order to watch content. For those who don't know, we bring television to the internet at Hulu, and we weren't otherwise going to require people to log in. You can just go to the site, click play, and watch a video. That was the business model. We didn't want to create too many barriers to entry and require people to create accounts. But in doing that, you raised this question, okay, well, can kids watch, mature content? And going back to the New York Times test, we said, look, we're not required to do anything here. There's nothing, legally that forces us to age gate. But we say to ourselves, we think it's the right thing to do. We'd rather not, even if we're not required to do anything, try to do something here. But then the question was, well, what do we do? And I think the point that, for some of you out there, this will resonate. You have to think about the resources that you have. And having a content rating system for thousands and thousands of shows is a very complicated thing. And frankly, when we launched with 30 people, we weren't equipped to handle any of that. So we came up with a much simpler system where we said, look, anything that was, an R-rated film or something that was rated TVMA, we would just lump all of those together and call it mature. We wouldn't give any explanations as to how it was mature, why it was mature, who said it was mature. But in that situation, and that situation only, we asked people to log in to confirm their age. And for us, that was all we could do at the time. And as we've grown and we've gotten better at things, our practices evolved. But early on, I think it's important to keep in mind that you don't necessarily have an army of lawyers and business people to tackle everything under the sun. So pick something that you think you can do do it well, and that's all we tend to focus on.
And that's a good place to end off the formal comments. We'd like to open it up for questions. Who wants the first question?
Hi, I'm Lisa from PayPal, and my question is around best practice. So I'm curious, when you come up with a best practice, how do you weigh between legal compliance, ROI, efficiency, and other measures?
That's why we get paid a lot of money. It's some of it's going to be your experience and remembering all the ugly moments, and some of it's going to be substantive knowledge. I think that that's the crux of the question, right? Balancing the risks of what your business does and what its identity is as well against what you're trying to achieve. I think, Chad, you said something really interesting, which is sometimes you just have to do the right thing, which is something we didn't really talk about at all, any of us, which is sometimes when you're flying without a substantive law behind what you're doing, there's a fair bit of common sense that comes in. It says, it's not just the New York Times, but is this what our users expect? Is this what we as a company want to be perceived as? And those are more subtle and gray questions than sometimes we want to admit. So,
good. Next question.
Hi, Stacy Olaf from NBC Universal. I just wondered if any of you had any comments on the recent Microsoft announcement that they were going to add individual arbitration provisions with class action waivers into all of their products and services in the coming future. They already have it on the Xbox, I think. And do you think that's going to become a best practice from the standpoint of providing a convenient, low-cost way for consumers to resolve their complaints with the company and hopefully be very consumer-friendly in their approach, but at the same time tackle the issue of these kind of abusive class action suits where there's little or no actual harm to a consumer who would feel compelled to bring an arbitration action or a small claims action, but you have multi-million-dollar fees being generated out of vindicating consumer rights.
I can take a run at it. We have not done that for our consumer arrangements and agreements at Google, but I have talked to a number of GCs who are seriously looking at it. I think it's a realistic option, maybe an attractive option for big companies that can invest a lot in customer support, customer service, because it's pretty clear under the Supreme Court rulings here that those arbitration agreements are enforceable if they're pretty darn consumer friendly. That is to say, the consumers need to be able to sue in their local or file for arbitration in their local area. You more or less need to be able to respond to them in a fairly spoon-fed way. So I think it's not really an option for the startups who don't have the ability to respond and go to 1,000 different jurisdictions around the country. It may be attractive for the reasons you articulate for larger companies, and I've seen in the last 6 months, a couple of dozen start to explore that.
Another area where this has come up for us is analyzing it less in the consumer context because, again, we're a B2B company, but having the arbitration class action waiver in employment agreements, because as many of you know, the wage and hour lawsuits that have been rampant, particularly in the Valley, with what I think any objective person would see as a very highly compensated workforce, is quite pernicious. And that's one area where if you've got a sizable workforce or you plan to have one, you may consider looking into having those waivers agreed to by your employees.
Okay, we can take 2 more questions, and then we go to the wine and cheese reception. I probably shouldn't have phrased it that way.
I don't want to stay between wine and cheese, but we're going to take 2 more. I'm Josh Becker from Lex Machina, and sort of looking at the stats, even outside of Google, there's about 44 open cases, IP cases represented on the panel. And we kind of heard earlier about, the need to, yeah,
I've got about 150.
yes. I left Google out of that one. But, about the need to, in defense, to be discerning. Actually, Jim was talking about that earlier. Have a reputation to be discerning and evaluating threat letters and cases, and as well as being potentially seen as punitive, being seen as being able to aggressively defend, essentially. And I'm wondering if anyone can comment on how you develop best practices, how you think about sort of developing a reputation around defense and best practices around that.
One good way is to take a hopeless case to the Supreme Court and win.
There you go. Thank you, Mike.
Go with that. That's great.
It's horses for courses. Every case is individualized. It is very clear that if you simply roll over on every case, the number of cases that you're going to have is just going to keep going up and up, because you will develop that reputation as a cash machine, an ATM, and there are lots of people out there who are more than happy to stick their card in the form of a complaint in and see how much cash comes out. At the same time, none of us have enough money. Even Kent doesn't have enough money to take every case, including all the ones that can ultimately, that can be settled fairly quickly for $50 or $100 or $150,000, all the way through trial. And so you have to sort of evaluate how good is the case, who's on the other side, is this an appropriate case to send a message, is this an appropriate case to write a check and get out early, how many other people have been sued, can you form a defense, either shared defense or form of defense association, which has gotten a little bit more complicated now that you're not readily handed the list of 44 defendants in the single case. I am very grateful to have a really good head of technology and patents and patent litigation, because it's not easy, but you are going to have to sort of sort through case by case by case, because there's no universal answer.
I'll add one thing to that. The nature of the plaintiff's bar in the kind of case you've settled. The plaintiff's bar in patent cases, and the patent trolls in particular, tends to be fairly tight-knit, and word travels fast. So we basically haven't settled many of those. In cases that we've taken quite a few to trial or to summary judgment, and we're either 15-1 or 16-0, depending on how you count. And we think that sends a pretty good message. So, while you can't take everything to trial, you pick your spots, and in an area like that where you've got a lot of issues and you're going to have a lot of issues for years to come, I think it is important to take a stand.
Last question.
Last one before the wine and cheese reception. Jennifer Sanders, I'm with Nickelodeon. And I just had some questions that kind of followed on Reggie's earlier comments on, it came up because of the different data collection from different apps on your mobile sites. And it's when you have a site and you're using different vendors for any practices on your site. So if you're using vendors for payment collection, rewards programs, anything else where the user is actually working with or interacting with those vendors, what are best practices around managing those vendors, both in, like, contractually, you're going to say, okay, if you're doing something on our site, we want indemnity, we want insurance. How far downstream do you go in managing that and looking at the insurance? And then at the companies, like I get pushback from business people all the time, we want this company, they have the biggest market share, and I'm looking at them going, but they have the riskiest practices out there. So it's where in evaluating those, what would be best practices and ideas?
Well, I raised the issue, but I didn't say I had the answers. Issue spotting. I mean, so at Yahoo, more mature company, a lot more energy went into that, a lot more aggressive analysis of all the partners. Zynga, not as many of those partners, not as much reliance there. Obviously, the first place to start is a lot of transparency and disclosure in your privacy policy that you're sharing information with third parties. And wherever you can do that at the time of the sharing or the collection of the data, not just in your privacy policy, but at point of location where you can make those disclosures, I think is really helpful. And then obviously there are negotiations around indemnities and protections, et cetera. But at Zynga, that's just not been as robust of an issue for us as it was at Yahoo.
Yeah, we very aggressively look at our vendors. We kind of learned the hard way that it doesn't matter what the contract says, if the company you're partnering with isn't reputable or doesn't have any money to stand behind any indemnity. And so at the business level, we very much work with folks to scrub all the vendors to make sure that they're reputable, they have good practices, and if they don't pass that smell test, we just won't partner with them.
Well, I'd like to invite everyone to continue the discussion. We want it to be interactive. We'd like you to stay for the wine and cheese. I'd like to thank the panel very much for a terrific panel and presentation. And I'd like to thank the audience for coming on behalf of Mark Lemley, myself, Bill Cosden, Roland Vogel, and we also want to thank the staff at Stanford for doing just a terrific job. But I'd like to ask a round of applause for the panel for a terrific